Welcome to another episode of the Neoliberal Round podcast. I'm Ronaldo McKenzie. Today is part 2 of the series, Castro v. Trump, where John Anthony Castro, the main plaintiff of this lawsuit, who is also the U.S. Republican 2024 presidential candidate, is running against a field of his peers to capture the nominee. And here is Mr. John Anthony Castro. How are you, John?
Good. Give me 1 second. I'm just going to make an adjustment. There we go. All right. I have some sensitive information on my screens here, so wanted to make sure it was blurred out.
Yes. All right. Let me actually Mr. John Anthony Castro. Welcome to the show, John.
Yeah. Thank you.
There we go. And we had part 1, and we provided an update as to what's going on with the Castro v. Trump lawsuit. But before we get into that, there is major news. Mr. Donald Trump, former President Donald Trump, is right now in court. I believe he's in court.
He just pleaded not guilty, and they're processing.
And I have several questions because I don't know if you're aware of what the 34 felonies are. How does this election violation affect the indictment, which is part of the felonies? And so I wanted to, I don't know if we can get into that a little bit. But officially, I want to say this, and I actually just tweeted. I said Trump did not want to run for president due to your case, but he also had to run to avert the DOJ's indictment. So in a sense, he said he was surprised, but was he cornered? Because here is it that you were filing a suit against him, against the FEC, saying that he should be eligible to run because he violated Section 3 of the 14th Amendment. According to that case was dismissed because according to the judge, FEC is only responsible to regulate campaign financing. Did that have any bearing on this DOJ's indictment?
Well, so it's important to remember that so at the federal level, he's still under investigation. At the state level, the district attorney brought a state grand jury indictment. And that's because the Manhattan district attorney, Alvin Bragg, is not subject to the DOJ policy that they don't indict an active candidate for the presidency of the United States. And so yes, when I initially brought this suit against the FEC and started putting pressure on Trump, he was advised by his attorneys that now would be a good time to announce his candidacy, become an official candidate, because if not, it was in this gray area where he was effectively campaigning, but technically still testing the waters. And so Merrick Garland and the federal DOJ were analyzing whether they could still go after him. But Merrick Garland said, no, it's not just presidential candidates, but what he called politically sensitive individuals. So, it's vague, right? There's a lot of ambiguity there. Like, what the hell does that even mean? And so, this uncertainty at the federal level and this lack of having a spine at the federal level was frustrating to state level. But at the same time, Manhattan District Attorney Alvin Bragg was basically like, hey, well, DOJ can have its policy, but the law is the law. It's supposed to be blind, right? You don't have a separate class, like the political ruling class is untouchable, is effectively what Merrick Garland's opinion and policy was stating. And so Alvin Bragg said, no, this is an individual that did, and it's important if you research this, you'll see that former vice presidential candidate John Edwards back in 2004 was convicted of the same exact offense.
Oh, wow. Yes, he was.
Yeah, he paid money to a woman he impregnated while his wife was dying of cancer. And, the Fox News just absolutely trashed him. But when you look at it, it's the same thing. It's a presidential or vice presidential candidate paying hush money to a mistress. And when that's done in the course of a campaign, then, that's considered, a campaign expense and a campaign violation. And at that time, Fox News jumped all over John Edwards, right? He's scum of the earth and all this, and there's no question it's a crime. And right now, seeing just the hypocrisy on Fox News, as they're saying, how is paying off a porn star, considered a campaign contribution? I didn't hear you making that objection back in 2005 when John Edwards was under federal indictment. So everybody at that time, even Democrats, universally agreed at that point. They were just like, yeah, that's a campaign finance violation. And, they did not try to defend him at all. They pretty much just said, yeah, he screwed up and that's it.
And McCarthy, I think, sorry but Pence and McCarthy and several other of your Republican friends are opposing this arraignment, indictment, saying that it is politically motivated. While they're not denying that he did it, they're not, but they are fighting it, saying that it is politically motivated, and they are opposing that. What does that say of the Republican Party and holding people accountable?
Yeah, it just, again, it's just classical hypocrisy from the current Republican Party that is in desperate need of being saved by a true conservative that actually understands the principles of the conservative political movement and doesn't get mixed up in all this trash. And it's just, it's unfortunate that the Republican Party right now is their main argument is paying off a porn star isn't a campaign finance violation. And then they went even further and said, okay, maybe it is a campaign violation, but either way, what gives Alvin Bragg the authority to enforce federal campaign finance laws? This is a federal campaign finance violation. Well, that's not correct, right? So what we know is that New York has mirror laws as well when it comes to campaign finance. New York also has state income tax returns, so if you deduct hush money that you use to pay off a porn star and you try to deduct it as legal fees by routing it through your lawyer, that's step transaction doctrine, right? I mean, that's not a legal fee that you pay to your attorney. That's hush money you paid to a mistress and a porn star. And so you're trying to deduct a payment to a porn star on your business tax return. It's just kind of like, no, you're going to jail. And it's unfortunate again that Irish criminal investigation isn't looking into this. I don't see them knocking on people's doors and asking questions about this payment. But Trump initiated an investigation of me by the IRS before he left office, and they tried targeting. They tried targeting me for many years and failed horribly because I'm a law-abiding citizen and I'm a legitimate tax attorney that honestly represents clients. And I push the bounds of interpretation on law, but that's called good lawyering. That's why I'm a millionaire. I think it's complete BS. They keep giving him a lot of softball passes, and it's about time that somebody held him accountable. And I honestly don't know why I haven't made a large contribution to District Attorney Alvin Bragg's office yet. But I'm pretty sure that in the coming days, when people realize what a patriot he is, the donations are going to come flooding in. There's plenty of valid reasons to critique some of his policies as district attorney in the state and city in the area of Manhattan. But what he's done here is historic and monumental, and he's definitely carved out a page in the history books.
And my question for you is, and of course, I wanted to find out was your previous case against the FEC, do you think that the FEC played a role in this indictment?
They could have possibly. Certainly this would have been initiated with complaints to both the Federal Election Commission as well as New York authorities regarding this payment. So, absolutely. I mean, to indict a former president of the United States, I can tell you right now, it's a team effort. And there are a lot of moving parts here. There's the U.S. Department of Justice, the Federal Election Commission, the New York State tax authorities. My case in particular, one of the intentional designs of my case is to neutralize one of Donald Trump's defenses, which is the same defense that Traitor-in-Chief Jefferson Davis back in the Confederate era, he used, which is that Section 3 of the 14th Amendment self-executing, and thereby, if he was prosecuted, would violate double jeopardy. And so my case is putting that issue center forward to neutralize that so that Jack Smith doesn't have any inhibition to bring a federal indictment and criminal prosecution of Donald Trump. So, again, there's a lot of implicit coordination, and we're all working together to make sure that, this man is held accountable. He has committed crimes left and right, but he has an army of attorneys advising him, through every avenue, and that's why, and he likes to add multiple layers of protection, and what people don't seem to realize here is there's a case for willful blindness when you're the head of an organization called the Trump Organization, right? The Trump Criminal Organization, and you intentionally insulate yourself from learning about certain things, about the scam of Trump University and all these other wrongdoings. And, I didn't read the tax returns of the organization that bears my name. There comes a point where all of that totality of circumstances establishes a very compelling case of willful blindness, right? If you've intentionally designed it to stay ignorant of what's going on within your organization, you can still be indicted and criminally prosecuted. And Donald Trump is finally being held accountable.
I have several questions regarding this case. If he is found responsible or is found guilty of the crimes here, does it disqualify him then, which is from running? And should the FEC continue can the FEC bar him from running because of this violation?
No, so unfortunately not. But it's going to be incredibly difficult to campaign if you're, in jail. But it's going to. I should clarify that statement. Donald Trump is really good at manipulating the legal system and dragging out the court cases. Like even in my case, every time there's 30 days for his side to respond, and the last day is like, let's say March 14th, they will respond at March 14th at 4:59 p.m. Right, like 60 seconds before. And the thing is that they're good at that, right? They want to drag out the deadline, and I can tell you that they're going to spend about 6 to 9 months challenging the manner by which the indictment was secured. So it's going to be 6 to 9 months before the indictment is even finally upheld to be valid. And then after that, is pre-trial, the evidentiary phase, right? So that's where you get to challenge what evidence is going to be included, not going to be included. And that can easily run 6 to 9 months as well. And then there's a lot of pre-trial preparation that can be another 6 months as well. So in other words, we're talking this case may be going to trial in 2025 or 2026.
After the presidential election.
Yes, exactly. So, I would characterize this as more of an insurance policy. If he were to somehow pull off the world's greatest stunning upset, which he pulled that fast one on us the first time, right? Because he was a clown, he was a joker, we didn't take him serious. He's not getting that pass again, right? He woke up a sleeping giant, and now all of us are fully activated. And that's why he lost the last election by 7 million votes. And trust me, he's going to lose the next one by 10 million votes. It's going to get even worse for him. So I don't think there's a chance in hell that he'll get elected. He hasn't gotten more popular since January 6th. That's for goddamn sure, right? I mean, he's only lost support within the Republican Party. The sensible ones that are not part of the cult have woken up and said, I can't be a part of this. So there's no chance in hell that he wins the election. And not only that, but again, my case and several others, like even Adrian Fontes, the Secretary of State in Arizona, he may actually on his own choose to not allow Trump on the ballot in Arizona. And there you go. There's a swing state he can't even have access to. So that being said, I can tell you right now that there's no chance he would get elected. But even if he did, again, let's assume coup d'etat happens, something, I don't know. The point is that this is an insurance policy against that very remote 1% out of 1% possibility, 0.001% chance. We now have an insurance policy against that. And so I can just tell you right now that it's over for him. That's what this indictment basically means. And so, it's going to be interesting. But next, and I can tell you right now that a lot of people think that this is the big one, right? But this, to me, represents two things. One, the insurance policy, and number two, it was a dry run to kind of see how the MAGA world would respond. Would they try to ransack the courthouse like they did with Congress on January 6th? But it's been pretty mellow, right? The crowds that are outside of the courthouse are actually anti-Trump crowds, right? There's very few pro-Trump people there. So what happened is, they all turned out to be, a bunch of chicken shits, didn't want to show up. And so now what that's going to do is that's going to embolden the DOJ at the federal level to say, okay, then we could bring an indictment of this guy. It's not going to be as bad as it was on January 6th. Most of the radicals that were even there on January 6th have all been arrested, right? They're all in decent jails. That sends a clear message to everybody else, F around, find out. And so, I think this is a dry run. They're also preparing to bring an indictment at the federal level. They already forced Pence to testify. They forced his attorney to testify. And actually this week, Judge Cannon is expected to issue a ruling on or before Friday.
I'm happy you said that. That's going to be my next question. And for those of us who are joining live on Facebook, welcome to part 2 of the series, Castro v. Trump. This is part 2, right here on the Neoliberal Realm podcast. And just so you know that Mr. Castro is the main plaintiff, and he's also running for president, and he's here with us, providing us an update. Now, the last time you had said that Donald Trump had applied for a motion to dismiss the case, your lawsuit against him, saying that he is ineligible. Now, however, but you had asked for a recusal of Judge Eileen Cannon. What's going on with Judge Eileen Cannon? Is she still on the case? Were you able to get her recused? What's going on?
Yeah, so the motion to recuse is on appeal right now via mandamus action before the U.S. Court of Appeals for the 11th Circuit. And so that's right now. We should have an answer by the end of next Friday, actually. So not an answer, sorry. They're going to docket the case. And then after they docket the case, they ask for a brief. So unfortunately, the wheels of justice turn incredibly slow, and there's nothing we can do about that. But next Friday, they would they would docket the case. Then they would set the schedule. So they would say, okay, my brief is due by this date. And then their response is due 30 days after that. So we're going to file it ASAP. We already have it ready to go, right? So as soon as they do that, they say, I got 30 days. No, to me, I got 30 minutes. I'm going to submit that like ASAP, because then that triggers their filing requirement and expedites it. So then they'll only have 30 days to respond. And then we're already going to have the response ready to go probably within 24 hours after theirs. And then after that, the court generally has 30 to 60 days. But in this case, they would likely expedite it to 30 days to make an official ruling. So that pretty much guarantees that I'd say by the end of May, so by June 1st, there should be a ruling on the mandamus. Now, that puts pressure on Judge Eileen Cannon, because right now, our little moles, in her court, among the clerks, have said that she's trying to craft an order right now, right? She's having to draft it up. She's trying to make it as logical as she possibly can. And so what's happening is they initially wanted to say that I don't have standing, but there was concern there because everything I've alleged has to be accepted as true in the dismissal phase. And so she's not allowed to make calls on questions of fact yet. And so for her to say that I don't have standing would violate well-established principles going back 150 years. And so basically the law clerks are like, Judge Cannon, like, we can't do that, right? I mean, that's going to further embolden his position that you're abusing your discretion. So what they advised her is, let's find standing, but then let's say that Section 3 of the 14th Amendment is not self-executing, doesn't provide independent grounds for, this case. And we can rule on that basis. But Judge Cannon is scared because that is the merits of the case, right? That allows me to then have a ruling on this from the Supreme Court before November, before we even file in New Hampshire. And so that's a big deal as well, right? And so she's just like, so she threw out the idea apparently to her law clerks, what if we just don't decide, right? Let's just withhold judgment. He would have to wait 90 days before he can not even file a writ of mandamus to try to force me to issue a ruling. But then they advised her, but he has the writ of mandamus already pending in the recusal. So the longer you wait and the more you abuse your discretion in withholding judgment, the more that it's going to prove that you are abusing your discretion, and they're going to cycle you out and put a new judge, most likely an Obama appointee, or even worse, a Bill Clinton appointee, or even a Bush Senior, right? Because or Bush Jr. because those are establishment Republicans who also despise Trump. So basically, it's not going to be good, and so they're stuck between a rock and a hard place because they're trying to decide, like, okay, then we have to issue a ruling. If we don't find standing, that they wouldn't just get easily overturned on that. That adds more credence to the abuse, and we get cycled out. But the what they're likely going forward with right now, and what one law clerk reported to us, is that they're going to find standing, but they're going to rule against the merits on Section 3. And that's going to undercut my claim that she's abusing her discretion, right? Because she's going to say, well, how can I be abusing my discretion? I found that you have standing, right? So that shows that I'm a fair and impartial judge. And to be honest, that would be a smart move, because she would likely then be able to stay on the case in the event that it was reversed and remanded back to trial. So that seems to be the leading contender, so to speak, of the position that they're going to take. And that's likely the order that they're drafting at this very moment right now in their chambers. The law clerks are all getting together and typing it out because, obviously they get their ass handed to them last time with the whole Trump intervention, and the 11th Circuit overturned her, said, hey, that was unconstitutional and abuse of discretion. So they don't want that to happen again. And so they're being very, very careful about it right now.
Okay. And as it relates, so what are the chances you think, in terms of the ruling next week, Friday, do you think, what do you think the ruling is going to be?
So actually, for the trial case for Judge Cannon, it's going to be most likely this Friday, and I think that she's going to issue an order stating that I do have standing, political competitor standing. However, I failed to state a claim upon which relief can be granted, which is that Section 3 of the 14th Amendment is not self-executing, doesn't provide independent grounds, and so it would be dismissed on that basis. And then what I would do is file a notice of appeal. And that's it. Now, the substance of the case goes to the United States Court of Appeals for the 11th Circuit. We'd see how they would rule. That's a toss-up. It's a conservative court, but it's an establishment conservative court, which means that they are not favorable towards Trump, but they are favorable towards Republicans, true conservative Republicans. And so it's going to be very interesting. It's a toss-up on how it could go. I really do think that the 11th Circuit has had enough of Trump. And I think they want to close the chapter. I think they want to provide a path for Ron DeSantis. And so I think they would hold that the Section 3 of the 14th Amendment does provide independent cause of action and remand that back down for trial. Now, at that point, Trump would appeal to the U.S. Supreme Court. And I think the smart move would be that they would simply deny certiorari, so they wouldn't take up the case. If they did, I do think they would uphold the 11th Circuit and basically hold that Section 3 of the 14th Amendment is self-executing, and again, remand it back down to the lower court for trial. And so at that point in November, we'd have that ruling. We would then immediately file what's called a Rule 12C motion for judgment on the pleadings and basically say, hey, look, there's no dispute of fact here. And we don't want to get Trump's deposition, right? Because he's going to argue privilege and all this other BS. So we're just going to argue, look, he said it on national TV. He also said he's part of the January 6th insurrectionists. We know that. We all saw it. So we're going to motion for judgment on the pleadings on that basis and then see how the court rules. And then that is what would be fast-tracked up to the Supreme Court again. And then at that point, there could be a ruling that he did. Now, if that happened, and let's say Supreme Court denied certiorari and the 11th Circuit upheld it, that is simply a court declaration stating that he did violate Section 3 of the 14th Amendment. Now what I have to do is, with that court order, I walk down to the Secretary of State's office in Pennsylvania, Michigan, Wisconsin, Arizona, Georgia, and I file state-level actions, and I say, I have a court order from the United States District Court for the Southern District of Florida stating that Donald J. Trump violated Section 3 of the 14th Amendment. And on that basis, he is ineligible to be on the ballot in this state. So I'd file a lawsuit against the Pennsylvania Secretary of State, Michigan, all of them. And that's that. They would basically say, well, we can't ignore a federal court order. And so then Donald Trump's name would be ordered removed from the ballots in those respective states. And there would be zero path for him to get to 270 electoral votes. So That would be it. That's the whole
Yes.
that's the whole thing in a nutshell.
In a nutshell. And for those of us who missed some of the arguments and the precedents that he's presenting before, you could check part 1 of the series. And so that's the ultimate goal for is that it will probably ultimately end up at the U.S. Supreme Court, who will make a ruling. And of course, some time ago, you were saying that you believe that most of the justices might side or may side with you.
Oh yeah, absolutely. I mean, because we got the 3 liberals on the court, right? Yeah, there's no question about that. Chief Justice John Roberts, he's on our side. We know that 100%. People would dispute that and be like, "Oh, well, no, trust me, he's 100% on our side." He's an institutionalist. He does not like Donald Trump's anti-institution, rhetoric. Yes. The question then at that point becomes, well, okay, that's 4. Who's your 5th vote? Well, number 1, there's 2 strategies. The first is compel a recusal of Justice Clarence Thomas, right? Because his wife was there at January 6th. There's no question it creates a public perception of partiality, and so if we could do that, then we'd be locked 4-4, which means whatever the 11th Circuit ruled would be upheld. And we know that they're going to side with us, right?
Yeah.
So that's strategy number 1. Strategy number 2, or option number 2, is Supreme Court Justice Neil Gorsuch. So Neil Gorsuch, he was obviously appointed by Trump. What a lot of people don't know is if you study his judicial philosophy, he's a libertarian. So he sympathizes with a lot of the arguments that Trump has about the deep state, which basically is this vast, unchecked bureaucratic state of unelected government bureaucrats that wield way too much power. And I agree with that. Like, I'm anti deep state big time. I want to rein in a lot of those executive powers, but also still, nevertheless, Neil Gorsuch is an institutionalist, and he really wants to preserve institutions, and he sees the threat that Trump poses to that. Brett Kavanaugh, I think at the end of the day, he's going to side with Trump, right? So, some people will call him 50-50. I don't buy it. I think Brett is just a Trump sycophant. But Gorsuch is guided by principles. He's a man of principles, and we are absolutely certain he would side with us. So even in the event that Justice Thomas didn't recuse, we know we got Roberts and Gorsuch and the 3 liberals, and right there we have 5-4, or if Thomas is out, 5-3. So again, I think that classical phrase of Donald Trump's days are numbered is really true here. There's a definite number of days that is left, right? And all he can try to do right now is run the clock and kick the can down the road, delay. But he's only delaying the inevitable. There is simply no path to him reclaiming the presidency. All he's trying to do right now is delay criminal prosecution and delay being held accountable. But he's pissed off too many people, including me. And I can tell you, when I get involved in something, I don't fail.
And we only. I'm going to try and wrap up in 2 minutes. We're trying to make this episode short so we could make it available quickly on Twitter and so on, since that's the new way now. And just so, your case is the only case right now that speaks to Mr. Trump violation of Section 3 of the 14th Amendment. And you're saying that because of that, he should not be a presidential candidate. Your case is the only case right now.
Yeah, it's the only case. And I can tell you the reason why no other Republican has brought this case is, number 1, they're spineless, right? Like, they lack executive leadership skills. So Ron DeSantis, Chris Christie, all these guys, right? They're a bunch of spineless scumbags, and they don't have the guts, right? It's just like, stand up for what you believe in, They like to call themselves, pretend that they're all alpha. It's just like, I don't think anything can get more alpha than challenging the most powerful politician on the planet Earth. So, I have that courage because I have that executive leadership. And that's the reason why, again, I'm offering that executive leadership to the people of this country. And it's just like, I am absolutely serious. I am campaigning for the presidency of the United States actively. I already have scheduled visits in New Hampshire with Republican